Hey guys, it's been a while. Thank you for standing by. This is Remedial Law Final Priority Notes. The General Principles of Remedial Law. Number 1. Doctrines in Remedial Law. Letter A. Doctrine of Primary Jurisdiction, which means that courts will not resolve a controversy involving a question which is within the jurisdiction of an administrative tribunal, especially where the question demands the exercise of sound administrative discretion requiring the special knowledge, experience, and services of the administrative tribunal to determine technical and intricate matters of the fact. Paloma versus Mora, GR 15773, no, GR 157783, September 23, 2005. If a case is such that its determination requires the expertise, specialized training, and knowledge of an administrative body, relief must first be obtained in an administrative proceeding before resort to the courts is had, even if the matter may well be within their proper jurisdiction. Another case is Euromed versus Province of Batangas, GR 148106. 2006, July 17. Third, the doctrine is also applicable to the exercise of power of the Office of the Ombudsman to conduct preliminary investigation over cases cognizable by the Sandiganbayan in the exercise of its original jurisdiction. Letter B. Doctrine of judicial stability when doctrine is not applicable. Judgment of a court of competent jurisdiction may not be opened, modified, or vacated by any court of concurrent jurisdiction. Panlilio et al. Versus Honorable Salonga GR 113087, June 27, 1994. This doctrine does not apply where a third-party claimant is involved and such claim is prosecuted in a proper action where the proper court issues a TRO or an injunction restraining the proceedings before its co-equal court. Villamor versus Guerrero, GR 8223842, 1991. Letter C. Doctrine of immutability of judgment when doctrine not applicable. The doctrine of immutability of judgments means that when a judgment becomes final and executory, it is made immutable and unalterable, meaning it can no longer be modified in any respect, either by the court which rendered it or even by this court, the Supreme Court. When a supervening event renders the execution of a judgment impossible or unjust, the interested party can petition the court to modify the judgment to harmonize it with justice and the facts. A supervening event is a fact which transpires or a new circumstance which develops after a judgment has become final and executory. This includes matters which the parties were unaware of prior to or during trial because they were not yet in existence at that. D versus Bibat Palomos, GR 196200, September 11, 2013. Letter D. Principle of judicial hierarchy of courts. The doctrine of hierarchy of courts, as a rule, requires that recourse must be first made to the lower ranked courts exercising concurrent jurisdiction with a higher court. Dio versus Subic Bay Marine Exploration, GR 189532, June 11, 2014. Letter E. Doctrine of adherence to jurisdiction or continuity of jurisdiction when not applicable. Jurisdiction once attached cannot be ousted by subsequent happenings or events, although of a character which would have prevented jurisdiction from attaching in the first instance, and the court retains jurisdiction until it finally disposes of the case. The doctrine shall not apply when 1. A subsequent statute expressly prohibits the continued exercise of jurisdiction. Number 2, the penal law where the action is based is repealed by a subsequent law. Number 3, constitutional right has been violated. Number 4, where the statute expressly provides or is construed to the effect that it is intended to operate as to actions pending before its enactment. Number 5, when the proceedings in the court acquiring jurisdiction is terminated, abandoned, or declared void. Number 6, appeal has been perfected. Number 7, curative statutes. Letter F, law of the case. Whatever is once irrevocably established as the controlling legal rule or decision between the same parties in the same case continues to be the law of the case, whether correct on general principles or not, so long as the facts on which such decision was predicated continue to be the facts of the case before the court. Letter G, administrative res judicata. The rule which forbids the reopening of a matter once judicially determined by competent authority applies as well to the judicial and quasi-judicial facts of public, executive, or administrative officers and boards acting within their jurisdiction as to the judgments of courts having general judicial powers. It has been declared that whenever final adjudication of persons invested with power to decide on the property and rights of the citizen is examinable by the Supreme Court upon a writ of error or a certiorari, such final adjudication may be pleaded as res judicata. People v. Ligtas, GR 207-51, August 17, 2015. Letter H, Doctrine of Stare Decisis. The doctrine of stare decisis, non quietumovir, or to adhere to precedents and not to unsettle things which are established, enjoins adherence to judicial precedents. It requires courts in a country to follow the rule established in a decision of the Supreme Court thereof. That decision becomes a judicial precedent to be followed in subsequent cases by all courts in the land. The doctrine of stare decisis is based on the principle that once a question of law has been examined and decided, it should be deemed settled and closed to further argument. Letter I, equity jurisdiction. Equity jurisdiction aims to provide complete justice in cases where a court of law is unable to adopt its judgments to the special circumstances of a case because of a resulting legal inflexibility when the law is applied to a given situation. The purpose of the exercise of equity jurisdiction, among others, is to prevent unjust enrichment and to ensure restitution. Regulus Development Inc. versus De La Cruz, GR 198172, January 2016. Split jurisdiction, letter J. The exercise by two judicial bodies of jurisdiction over basically the same subject matter, precisely the split jurisdiction situation, which is anathema to the orderly administration of justice. City of Manila versus Judge Cuerdo, GR 175723, 2014. Letter K, expanded jurisdiction. Jurisdiction of a court which is expanded and its rank elevated to that of a collegiate court with special jurisdiction. C.E. Casecnan Water and Energy Company versus the Province of Nueva Ecija, GR 196728, 2015. Letter I is residual jurisdiction. The residual jurisdiction of trial courts is available at a stage in which the court is normally deemed to have lost jurisdiction over the case or the subject matter involved in the appeal. This stage is reached upon the perfection of the appeals by the parties or upon the approval of the records on appeal, but prior to the transmittal of the original records or the records on appeal. In either instance, the trial court still retains its so-called residual jurisdiction to issue protective orders, approve compromises, permit appeal of indigent litigants, order execution pending appeal, and allow the withdrawal of the appeal. Caton versus Palanca Jr., GR 151149, 2004. Number 2. General Principles on Jurisdiction. Jurisdiction is the power of the court conferred by law to hear, try, and decide a particular class of case. Concurrent jurisdiction means it is the power of two or more courts of different levels to exercise original jurisdiction over a particular case. General jurisdiction means that those with competence to exercise jurisdiction over cases not falling within the jurisdiction of any court, tribunal, person, or body exercising judicial or quasi-judicial functions. Limited jurisdiction. It means that limited power of the court to hear, try, decide cases that are expressly provided by law. Original jurisdiction means jurisdiction of first instance. Appellate jurisdiction, the power of the court to reverse, modify, or affirm decisions or orders of a lower court. Number 3. Jurisdiction of courts, regional trial courts. Exclusive jurisdiction of the regional trial courts. In civil case, actions in which the subject of litigation is incapable of pecuniary estimation. Number 2. Actions which involve the title to or possession of real property or any interest therein, where the assessed value exceeds 20,000 or 50,000. In Metro Manila, except forcible entry and unlawful detainer. Exceeding 300,000 outside Metro Manila or 400,000 in Metro Manila. Number 3. Actions in admiralty and maritime jurisdictions. Number 4. Matters of probate, testate, or intestate. Basis is the gross value of the state. Number 5. Other cases where the demand, exclusive of interest, damages, attorney's fees, litigation expenses and cost, or value property in controversy. Others, like cases not within the exclusive jurisdiction of any court, tribunal, person or body exercising judicial or quasi-judicial action. Number 7, civil actions and special proceedings falling within exclusive original jurisdiction of juvenile and domestic relations court and court of agrarian reforms. Number 8, intra-corporate controversies under Section 52 of the Securities and Regulation Code, special commercial courts. Now, under criminal case for regional trial courts, number 1, criminal cases not within exclusive jurisdiction of any court, tribunal, or body, Section 20 of BP 129, like criminal cases where the penalty provided by law exceeds 6 years imprisonment, irrespective of the fine, RA 7691. Letter B, criminal cases not falling within the exclusive original jurisdiction of the Sandiganbayan, where the imposable penalty is imprisonment more than 6 years and not occupying positions classified as grade 27 and higher. Section 4 PD 1606 as amended by RA 8249. Cases where the only penalty provided by law is a fine exceeding 4,000. As specified by law, a law on written defamation or libel is under RTC. Letter B, decree on intellectual property. C, violation of dangerous acts or drugs acts regardless of the imposable penalty except when the offender is under 16 and there are juvenile and domestic relations court in the province. Cases falling under the family courts in areas where there are no family courts, Section 24 of BP 129. E. Election offenses regardless of salary grade. Letter F. Violations of cybercrime law. And G. Violation of election laws. Special jurisdiction. Supreme Court may designate certain branches of RTC to try exclusive criminal cases, juvenile and domestic relations cases, agrarian cases, urban land reform cases not falling within the jurisdiction of any quasi-judicial body, and other special cases in the interest of justice. Concurrent jurisdiction. This is with MTC. Cases involving enforcement or violations of environmental and other related laws, rules, and regulations. Section 2, Rule 1 of AM number 0968 SC. Concurrent jurisdiction with CA. 1. Writ of amparo. Number 2. Writ of habeas data. Number 3. Writ of habeas corpus. Number 4. Certiorari, mandamus, and prohibition. Number 5. Quo warranto. With concurrent with the Supreme Court, as Sandiganbayan and CA, that would be 1. Writ of amparo. Number 2. Writ of habeas data. With Sandiganbayan, writ of amparo, writ of habeas data. With the Supreme Court, again, writ of amparo, writ of habeas data, certiorari, mandamus, and prohibition, plus quo warranto, finally actions affecting ambassadors and other public ministers and consuls. Appellate jurisdiction. All cases decided by lower courts in their respective territorial jurisdictions, except decisions of MTC in the exercise of its delegated jurisdiction. Now, jurisdiction of courts, Sandiganbayan. Criteria to determine whether the Sandiganbayan has jurisdiction. Letter A. What offense was committed? B. Who committed the offense? C. How the offense was committed. So under A, what offense was committed for Sandiganbayan? Number 1, R83019, Anti-Graft and Corrupt Practices Act. Number 2, R81379, the Act declaring forfeiture in favor of the state any property found to have been unlawfully acquired by any public officer or employee and providing for the proceeding thereof. Number 3, violation of EO 1214, 14A, PCGG cases. Number 4, bribery under RPC. Number 5, estafa, Serrano versus Sandiganbayan, GR 162059, 2008. And finally, falsification. Case is Remedial versus Sandiganbayan, GR numbers 140576299, December 13, 2004. Note the averments on solicitation of money in the information committed by public officers enumerated as falling under the jurisdiction of Sandiganbayan, which may be taken as constitutive to or bribery, may form part of illegal drug trading, which is cognizable by RTC and not the Sandiganbayan. Senator Leila de Lima versus Honorable Juanita Guerrero, GR 229781, October 10, 2017. How about B? Who committed the offense? Officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 and higher, of the Compensation and Position Classification Act of 1989, specifically including A. Provincial governors, vice governors, members of the Sangguniang Panlalawigan and provincial treasurers, assessors, engineers, and other provincial department heads. B. City mayors, vice mayors, members of the Sangguniang Panlusod, city treasurers, assessors, engineers, and other city department heads. Letter C. Officials of the diplomatic service occupying the position of consul and higher. D. Philippine Army and Air Force colonels, naval captains, and other officers of higher rank. officers of the Philippine National Police while occupying the position of provincial director and those holding the rank of senior superintendent or higher. City and provincial prosecutors and the assistants, and officials and prosecutors in the office of the Ombudsman and Special Prosecutor. G. Presidents, directors of justice, or managers of government-owned or controlled corporations, state universities, or educational institutions or foundations. Number 2, members of the Congress and official thereof, classified as grade 27 and up under the Compensation and Position Classification Act. Number 3, members of the judiciary without prejudice to the provisions of the Constitution. Number 4, chairmen and members of constitutional commissions without prejudice the provisions of the Constitution. Number 5, all other national and local officials classified as grade 27 and higher under the Compensation and Position Classification Act. Letter C, how the offense was committed. Offenses are felonies, whether simple or complex, with other crimes committed by the public officials and employees in relation to their office. For the Sandiganbayan to have exclusive jurisdiction over crimes committed by public officers in relation to their office, it is essential that the facts showing the intimate relation between the office of the offender and the discharge of official duties must be alleged in information. It is not enough to merely allege in the information that the crime charge was committed by the offender in relation to his office, because that would be a conclusion of law. Escobar versus Garchi-Torena, GR 124644, 2004. Appellate jurisdiction. Final judgments, resolution, or orders of regional trial courts, whether in the exercise of their own original jurisdiction or of their appellate jurisdiction over crimes and civil cases falling within the original exclusive jurisdiction of the Sandiganbayan, but which were committed by public officers below salary grade 27 or RA 8249. Appellate or concurrent jurisdiction with the Supreme Court. Number 1, petitions for certiorari, prohibition, mandamus, habeas corpus, injunction, and other ancillary writs in aid of its appellate jurisdiction, including co-warrantorizing in cases falling under Executive Order numbers 1, 2, 14, and 14-A. Number 2, petitions for the issuance of writ of amparo and writ of habeas data. Concurrent with CA and RTC would be petitions for the issuance of writ of amparo and writ of habeas data. Concurrent with CA, petitions for certiorari, prohibition, mandamus, habeas corpus, injunction, and other ancillary writs in aid of its appellate jurisdiction, including co-warrantorizing in cases falling under Executive Order numbers 1, 2, 14, and 14-A, petitions for the issuance of writ of amparo and writ of habeas data. With CA and RTC together, that would be petitions for the issuance of writ of amparo and writ of habeas data. Number 5, jurisdiction, small claims, cases, summary, and barangay conciliation. Rule on small claim cases, which is under the civil case, we have small claim cases, civil claims, which are exclusively for the payment or reimbursement of a sum of money not exceeding 200,000, exclusive of interest and costs, either 1, purely civil in nature, where the claim or relief prayed for by the plaintiff is solely for payment or reimbursement of sum of money, or number 2, the civil aspect of criminal actions, either filed before the institution of the criminal action or reserved upon the filing of the criminal action in court pursuant to Rule 111 of the Revised Rules of Criminal Procedure, or AM number 08-8-7 SC 2016 Revised Rules of Procedure for Small Claims. Note, the threshold was increased to 300,000 pesos, exclusive of interest and costs, pursuant to OCA Circular Number 165, 2018, and Bank Resolution dated July 10, 2018. Rules on Summary Procedure. All cases of forcible entry and unlawful detainer, irrespective of the amount of damages or unpaid rentals sought to be recovered, where attorneys' fees are awarded, the same shall not exceed 20,000, and 2. All other civil cases except probate proceedings, where the total amount of plaintiff's claim does not exceed 100,000 or does not exceed 200,000 in Metro Manila, exclusive of interest and costs. AM number 0211-09 SC. Under criminal cases, for the rules and summary procedure, number 1, violations of traffic laws, rules, and regulation. Number 2, violations of the rental law. 3, violations of municipal or city ordinances. 4, violations of PB22 or the bouncing checks law. Number 5, all other criminal cases where the penalty is imprisonment not exceeding 6 months and or a fine of 1,000 irrespective of other penalties or civil liabilities arising therefrom, and 6, offenses involving damage to property through criminal negligence, where the imposable fine is not exceeding 10,000. Cases not covered. This rule shall not apply to a civil case where the plaintiff's cause of action is pleaded in the same complaint with another cause of action subject to the ordinary procedure, nor to a criminal case where the offense charge is necessarily related to another criminal case subject to the ordinary procedure. Section 1, AM number 022-9 SC 2005. Aspects of jurisdiction. Subject matter, meaning the power to hear and determine cases of the general class to which the proceedings in question belong and is conferred by the sovereign authority which organizes the court and defines its power. Who conferred? Conferred by law. Parties. It is the legal power of the court to render personal judgments and against a party to an action or proceeding. How conferred? Plaintiff, by the filing of the complaint and timely payment of the correct docket fees. As for the defendant, valid service of summons or the voluntary appearance in court. Intervenor, upon the approval of the motion for leave to intervene. Issues. Power of the court to try and decide issues raised in the pleadings of the parties or their agreements in a pretrial order or those tried by the implied consent of the parties. And this is determined by the allegations in the pleadings. Res. Jurisdiction over the thing which is the subject of the case. Number 1, by the seizure of the property under legal process, whereby it is brought into actual custody of the law, example attachment, or as a result of the institution of legal proceedings in which the power of the court is recognized or made effective. Number 7, distinguish residual prerogative from residual jurisdiction. Residual prerogative. This is the general residual powers of the court to dismiss an action motu proprio upon the grounds mentioned in Section 1, Rule 9. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived, except when number 1, lack of jurisdiction over the subject matter, number 2, litis pendentia, number 3, res judicata, and 4, prescription are evident from the pleadings or the evidence on record. In the fourth excepted instance, the court shall motu proprio dismiss the claim or action. Residual jurisdiction, on the other hand, embodied in Rule 41, Section 9. The residual jurisdiction of trial courts are available at a stage in which the court is normally deemed to have lost jurisdiction over the case or the subject matter involved in the appeal. This stage is reached upon the perfection of appeals by the parties or upon the approval of the records of appeal, but prior to the transmittal of the original records or records in appeal. In either instance, the trial court still retains its so-called residual jurisdiction to issue protective orders, approve compromises, permit appeals of indigent litigants or their execution pending appeal, and allow the withdrawal of the appeal. Capton versus Palanca GR 151149, September 2004. Number 8, grounds where the court may dismiss the case motu proprio. Number 1, lack of jurisdiction over the subject matter. Number 2, litis pendentia. Number 3, res judicata. And number 4, prescription. Others, when the plaintiff fails to appear on the date of the presentation of evidence in chief on the complaint. Number 2, to prosecute his action for an unreasonable length of time. Number 3, to comply with the rules or any order of the court. Number 4, in summary procedure, the court may dismiss the case outright on any of the grounds for the dismissal of a civil action apparent from the examination of the allegation in the pleadings and the evidence attached thereto. Number 9, does voluntary appearance in court automatically result to submission to the court's jurisdiction? The answer is no. Voluntary appearance in court may not always result in submission to the jurisdiction of a court. When a party makes a special appearance to challenge, among others, the court's jurisdiction over his person, he cannot be considered to have submitted to its authority. Special appearance operates as an exception to the general rule of voluntary appearance. Accordingly, objections to the jurisdiction of the court over the person of the defendant must be explicitly made, that is, set forth in an unequivocal manner. Sunrise Garden versus Court of Appeals. Number 10, what is the force and effect of a kasunduan in barangay conciliation proceedings? The amicable settlement and arbitration award shall have the force and effect of a final judgment of a court upon the expiration of 10 days from the date of its execution, unless the settlement or award has been repudiated or a petition to nullify the award has been filed before the proper city or municipal court. Number 11, considering that decision in small claims cases are immediately executory and unappealable, what can be the proper remedy for an aggrieved party? The proscription on appeals in small claims cases similar to other proceedings where appeal is not an available remedy does not preclude the aggrieved party from filing a petition for certiorari under Rule 65 of the Rules of Court. AL, ang Network versus Mondejar, GR 200-804, January 22, 2014. Number 12, can the CDA exercise jurisdiction over a special civil action for certiorari assailing an interlocutory order issued by the RTC in a local tax case? Yes, when jurisdiction is conferred by law to the court or judicial officer. All auxiliary writs, processes, and other means necessary to carry it into effect may be employed by such court or officer. A grant of appellate jurisdiction implies that there is included in it the power necessary to exercise it effectively, to make all orders that will preserve the subject of the action, and to give effect to the final determination of the appeal. City of Manila versus Honorable Gracia Cuerdo, CGR 175723, February 2014. Number 13, X. A high school student filed an administrative case before the Civil Service Commission, Cordillera Autonomous Region, or CSC CAR, against a teacher in his school. Y, for allegedly punching X in the stomach because of the latter's failure to follow Y's instructions of falling in line. The CSC CAR took cognizance of the case and ruled in favor of X. On appeal, Y sought to annul the decision of the CSC CAR for lack of jurisdiction over the subject matter, contending that the administrative case against him should have been filed before the Department of Education. Is Y's argument correct? The answer is no. The CSC, the Department of Education, DepEd, and the Board of Professional Teachers Professional Regulatory Commission, or PRC, have concurrent jurisdiction over administrative cases against public school teachers. Where concurrent jurisdiction exists in several tribunals, the body that first takes cognizance of the complaint shall exercise jurisdiction to the exclusion of the others. Here, it was CSC which first acquired jurisdiction over the case because the complaint was filed before it. Thus, it had the authority to proceed and decide the case to the exclusion of the DepEd and the Board of Professional Teachers. PART1 versus Civil Service Commission, GR 198755, June 5, 2013. Number 14. What are the two aspects of res judicata? Bar by prior judgment is 1. Section 47, letter B of Rule 39. There is identity of parties, subject matter, and causes of action between the first case, where the judgment was rendered, and the second case that is sought to be barred. The judgment in the first case constitutes an absolute bar to the second action. The second aspect of res judicata is conclusiveness of judgment. Section 47, letter C of Rule 39. There is identity of parties and issues in the first and second cases, but no identity of cause of action. The first judgment is conclusive only as to those matters actually and directly controverted and determined, and not as to matters merely involved therein. Any right, fact, or matter in issue directly adjudicated or necessarily involved in the determination of an action before a competent court in which judgment is rendered on the merits is conclusively settled by the judgment therein and cannot again be litigated between the parties and their privies, whether or not the claim, demand, purpose, or subject matter of the two actions is the same. What is the aspect of jurisdiction that may be barred by estoppel? The aspect of jurisdiction which may be barred from being assailed as a result of estoppel by laches is jurisdiction over the subject matter and not that of the jurisdiction over the party. The principle of estoppel by laches finds no application on lack of jurisdiction over the person of the defendant. Instead, the principles relating to jurisdiction over the person of the parties must apply. That is, lack of jurisdiction over the person of a party is not one of those defense considered waived under Section 1 of Rule 9. Such defense must be invoked when an answer or a motion to dismiss is filed. Otherwise, it is deemed waived. Boston Equity versus Court of Appeals, GR 173946, 2013. Now, under civil procedure, what are the requisites for joinder of causes of action? 1. Where the claims and the causes of action are principally for the recovery of money, the aggregate amount claimed shall be the test of jurisdiction. Number 2, the joinder shall not include special civil actions or actions governed by special rules. Number 3, the party joining the cause of or causes of action must comply with the rules on joinder of parties. And number 4, where the causes of action are between the same parties but pertain to different venues or jurisdiction, the joinder may be allowed in the RTC provided one of the causes of action fall within the jurisdiction of said court and the venue lies therein. Number 17, K lent $250,000 to J, which remains unpaid despite several demands by K. J also entered into a contract for service with J. However, J has breached a material provision of the contract for services. K filed a complaint against J. I think this should be K also entered into a contract for service with J. However, J has breached a material provision of the contract for services, so K filed a complaint against J before the MTC of Baguio, wherein he joins the cause of action for collection and rescission. Should the joinder of causes of action be allowed? The answer is no. The joinder of causes of action should not be allowed. While the MTC has jurisdiction over the cause of action involving collection, it has no jurisdiction over the cause of action involving rescission, which is incapable of pecuniary estimation. Hence, the cause of action involving the rescission should be severed. Primary Reviewer on Remedial Law, Volume 1, under Riguera, Manual R, 2015. What is totality rule? Where there are several claims or causes of actions between the same or different parties embodied in one complaint, the amount of the demand shall be the totality of the claims in all causes of action, irrespective of whether the causes of action arose out of the same or different transaction. Rule 2, Section 5. Number 19. What is the rule on splitting a single cause of action? The rule is that a party may not institute more than one suit for a single cause of action. If two suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. In other words, the ground for dismissal is either lis pendens or res judicata. Sections 3 and 4, Rule 2. Number 20. The complaint filed before the RTC of Manila states two causes of actions, one for collection of sum of money amounting to 100,000 and the other for collection of loan amounting to 500,000. Is the joinder of the two causes of action proper? No, under Section 5, letter C of Rule 2, the joinder shall not include actions governed by special rules. Here, the action for collection of 100,000 is governed by a special rule of procedure for small claims. Hence, the joinder is not proper. This is from Riguera. Number 21, P. A Manila resident filed a complaint against D, a resident of Iloilo City, in the RTC of Manila. The complaint joins two causes of action, one for collection of 300,000 and the other for recovery of title for real property in Iloilo with assessed value of 100,000. Both of causes of actions arise out of the same transaction between the parties. Were there proper joinder of action? The answer is still no. While the real action falls within the jurisdiction of RTC, the venue does not lie therein, but with RTC Iloilo. The rule uses the conjunction and. B. If you were the lawyer for D, what would you do? I would file a motion to dismiss on the ground of lack of jurisdiction and improper venue. Since there was improper joinder, the two causes of action should have been filed separately. The RTC has no jurisdiction over a claim not exceeding 300,000, and the venue of real property is misplaced, as the same should be filed in Iloilo City. Bernadette Dance Flo entered into a lease agreement with Joanne, married to Anthony, who is in the business of buying and selling cars, whereby one of the cars owned by a sole proprietorship called Jotan Enterprises, registered under the name of Joanne, was leased to Bernadette. The checks paid by Bernadette, however, were dishonored. Joanne thus instituted an action for recovery of the leased car against Bernadette. Bernadette claims that Anthony should be impleaded as an indispensable party. Is Bernadette correct? No. Jotan Enterprises as a sole proprietorship is a conjugal property, hence the rules on co-ownership apply. In suits to recover properties, all co-owners are real parties in interest. However, pursuant to Article 487 of the Civil Code, any one of them may bring an action, any kind of action, for the recovery of co-owned properties. Therefore, only one of the co-owners, namely the co-owner who filed the suit for the recovery of the co-owned property, is an indispensable party thereto. The other co-owners are not indispensable parties. They are not even necessary parties, for a complete relief can be accorded in the suit even without their participation, since the suit is presumed to have been filed for the benefit of all co-owners. Anthony only needs to be impleaded as a pro forma party to the suit, based on Section 4, Rule 4 of the Rules of Court. Number 23. What is the remedy for an action brought not in the name of a real party in interest? A suit that is not brought in the name of a real party in interest is dismissible on the ground that the complaint fails to state a cause of action. That is Caja Contreras versus Water, GRL 60201. That's a 1984 case. Number 24. Alvin, Bato, and Coco co-own the land in Dagupan. Alvin filed an ejectment suit against Digong, alleging that the latter is occupying part of their land. Digong filed a motion to dismiss the ejectment suit for failure of Alvin to implead Bato and Coco as parties. Rule on the motion. Digong's motion to dismiss must be denied, where the ejectment suit is brought by co-owner without repudiating the co-ownership. Then the suit is presumed to be filed for the benefit of the other co-owners, and may proceed without impleading the other co-owners. The other co-owners are not considered as indispensable parties to the resolution of the case. Here, Alvin filed the ejectment case against Digong without repudiating his co-ownership with Bato and Coco. Thus, the suit is presumed for the benefit of Alvin's co-owners, and it may proceed without impleading Bato and Coco. Marmo versus Anakai, GR 11 or 18285, 2009. Number 25. Is the non-joinder of indispensable parties a ground for dismissal of an action? No. The non-joinder of indispensable parties is not a ground for dismissal of action. Section 11, Rule 3 of the Rules of Court prohibits the dismissal of a suit on the ground of non-joinder or misjoinder of parties and allows amendments of the complaint at any stage of the proceedings through motion or order of the court on its own initiative. Only if plaintiff refuses to implead an indispensable party, despite the order of the court, may it dismiss the action. Valdez-Talorin versus Ears of Juanito Torona, GR 177429, November of 2009. Number 26. What is the effect of not impleading indispensable parties? Joinder of indispensable parties is mandatory. Without the presence of indispensable parties to the suit, the judgment of the court cannot attain real finality. Strangers to a case are not bound by the judgment rendered by the court. The absence of an indispensable party renders all subsequent actions of the court null and void, with no authority to act, not until all of the absent party, but also as to those present. Commissioner Andrea D. Domingo versus Herbert Marcus Emil Ashir, GR 154745 of 2009, January. Number 27. Requisites of a class suit, or CRIB. Number 1. The subject matter is one of common or general interest to many persons. Number 2. The parties actually before the court are sufficiently numerous and representative as to fully protect the interests of all concerned. Number 3. The persons are so numerous that it is impracticable to join all of them as parties. Number 4. The representatives sue or defend for the benefit of all. Number 28. What is the effect of the death of a party upon a pending action? Letter A, purely personal, extinguishes the claim and the action is dismissed. Letter B, not purely personal, claim is not extinguished and the party should be substituted by heirs, executor, or administrator. In case of minor heirs, the court may appoint a guardian ad litem for them. Letter C, action for recovery of money arising from contract, and the defendant dies before entry of final judgment. It shall not be dismissed, but instead it shall be allowed to continue until entry of judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner provided in the rules for prosecuting claims against the estate of a deceased person. Number 29. Who are pauper litigants in an indigent party? Pauper litigants are those: A, whose gross income and that of their immediate family do not exceed 4,000 pesos a month if residing in Metro Manila, and 3,000 pesos a month if residing outside Metro Manila. And B, who do not own real property with an assessed value of more than 50,000 pesos. They shall be exempt from the payment of legal fees. On the other hand, an indigent party is one who has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. They shall be exempt from payment of docket and other lawful fees, and of transcripts of stenographic notes which the court may order to be furnished him. Number 30. Can a juridical person be regarded as an indigent litigant? No. The clear intent and precise language of the rules of court indicate that only a natural party litigant may be regarded as an indigent litigant. A juridical person cannot be accorded the exemption from legal and filing fees granted to indigent litigants. There are other reasons that warrant the rejection of the request for exemption in favor of a juridical person. For one, extending the exemption to a juridical person on the ground that it works for indigent and underprivileged people may be prone to abuse, even when the imposition of rigid documentation requirements, particularly by corporations and entities bent on circumventing the rule on payment of the fees. Also, the scrutiny of compliance with the documentation requirements may prove too time-consuming and wasteful for the courts. Query of Mr. Roger Perio Orechi, exemption from legal and filing fees of the Good Shepherd Foundation. Number 31. State the rules on venue of civil actions. Where a specific rule or law provides the venue, the same shall be followed. Section 4, letter A, Rule 4. B. If there is no law or rule providing for the venue and there is a stipulation between the parties as to the venue, the same shall govern, provided it contains restrictive words like only, solely, exclusively in this court, no other court save, particularly nowhere else but except, or words of equal import. Pacific Consultants versus Schoenfeld, GR 166920, February 2007. Letter C. In cases where there is no rule or law providing for the venue, or where there is no venue stipulation, the venue depends on whether the action is real or personal. Number 32. BPI Family Bank filed with the RTC of Makati an action to recover deficiency against the real estate mortgagors after the extrajudicial foreclosure sale had resulted in a deficiency. The realty mortgaged was located in Manila, while BPI has its main office in Makati. The mortgagors filed a motion to dismiss on the grounds of failure to state a cause of action, res judicata, and waiver. The RTC denied the motion. The mortgagors filed a motion for reconsideration, wherein they reiterated the previous grounds and added the ground of improper venue, contending that the action for deficiency was a real action which should have been brought in Manila. The RTC granted the motion and dismissed the complaint for improper venue. Was the dismissal proper? The answer is no. An action to recover the deficiency after extrajudicial foreclosure of a real estate mortgage is a personal action, since it does not affect title to or possession of real property or any interest therein. Hence, the action was properly brought in Makati, where the BPI has its main office, and even assuming that there was improper venue, the ground was waived by the mortgagors since they did not timely raise in their motion to dismiss. The ground of improper venue was raised belatedly in the motion for reconsideration, not in the motion to dismiss. Hence, the objection was waived pursuant to Section 1, Rule 9. Compulsory counterclaim from permissive counterclaim. But before that, the case above is BPI Family Savings Bank versus Spouses Juico, GR 175796, 2015, July 22nd. Now, compulsory counterclaim. If not set up in an action, it is deemed barred. No docket fees. As a rule, it not be answered. Allowed under the rule on summary procedure, it need not be accompanied by a certification against forum shopping. For permissive, even if not set up as an action, it is not barred. Filing fees need to be paid. It should be answered, otherwise the plaintiff could be declared in default in respect thereof. Prohibited under the rule on summary procedure, and it must be accompanied by a certification against forum shopping. So that's the difference. Number 34. What are the requisites of a compulsory counterclaim? Number 1, it must arise out of or be necessarily connected with the transaction or occurrence that it is the subject matter of the opposing party or co-party's claim. Number 2, it does not require for its adjudication the presence of third parties over whom the court cannot acquire jurisdiction. And 3, cognizable by the regular courts of justice. And number 4, it must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. 35. What are the criteria or tests to whether a counterclaim is compulsory or permissive? Under Section 7, Rule 6, parties in interest without whom no final determination can be had of an action shall be joined either as plaintiff or defendants. The criteria are liar, L-I-R-E. L, is there any logical relation between the claim and the counterclaim? I, are the issues of fact or law raised by the claim and the counterclaim largely the same? R, would a res judicata bar a subsequent suit on defendant's claim absent the compulsory counterclaim rule? And letter E, will substantially the same evidence support or refute plaintiff's claim as well as the defendant's counterclaim? Aldi versus FGU Insurance Corporation, GR 138822, 2001, January 23rd. Number 36. May a compulsory counterclaim or cross-claim not set up in the answer still be raised subsequently? No, because compulsory counterclaim or cross-claim not set up in the answer is deemed barred. Exceptions. A counterclaim or which either matured or was acquired by a party serving as pleading may, with the permission of the court, be presented as a counterclaim or cross-claim by supplemental pleading before judgment. Number 2, omitted counterclaim through oversight, inadvertence, or excusable neglect. 37. What is the effect of dismissal of the complaint on the defendant's counterclaim? Where the plaintiff moves for the dismissal of his complaint to which a counterclaim has been interposed, the dismissal shall be limited to the complaint. Such dismissal shall be without prejudice to the right of the defendant to either prosecute his counterclaim in a separate action or to have the same result in the same action. Should he opt for the first alternative, the court should render the corresponding order granting and reserving his right to prosecute his claim in a separate complaint. Should he choose to have his counterclaim disposed of in the same action wherein the complaint had been dismissed, he must manifest such preference to the trial court within 15 days from notice to him of plaintiff's motion to dismiss. These alternative remedies of the defendant are available to him regardless of whether his counterclaim is compulsory or permissive. Lim Tech 1 versus UI GR 155701. Okay, stand by for part 2, but let's end it with a quote from Justice Leonen. For those who will become lawyers, remember that the profession is not at all that you are. Be humble, resist greed, learn to sacrifice. Every privilege comes with responsibilities. Spider-Man. No. Address inequality. Strive for social justice. Serve the people. Marvick Leonen, Supreme Court Associate Justice. And of course, if you're not yet subscribed, go ahead and hit that subscribe button and let's study together. Bye.